So, good afternoon. We are here in Structurlam Mass Timber, case number 23-10497. Counsel, you can proceed.
Good afternoon, Your Honor. William Chipman, Brown, Cicero, and Cole, counsel for the debtors. I want to thank Your Honor first for entering orders for many of the matters set forth on today's agenda. I think the only two remaining matters are the sale motion and the keep and curb motion. So if it pleases the court, I'll turn to the sale motion first.
Certainly.
Thank you, Your Honor. We are pleased to report that we received a competing bid for the debtors' assets and conducted a very successful auction last Wednesday. At the conclusion of the auction, the debtors, in consultation with the consultation parties, selected Mercer International, Inc. as the winning bidder with its final bid of $83.5 US for substantially all the debtors' assets in the United States and Canada. The debtors also selected Weyerhaeuser Company as the backup bidder with its final bid in the amount of $80 million US to acquire substantially all the assets of the debtors related to their United States operations only. We did receive two cure objections, Your Honor, that have been continued until the next hearing. However, given that Mercer has indicated it will not at this time assume any assets or have any assets assumed and assigned to it, they may be moot, but I think they're going to have more time to make that determination. So it's not a today issue, Your Honor. With regard to approval of the sale itself, I believe we're here on a fully consensual basis. As Your Honor is aware, prior to the petition date, the debtors negotiated the principal terms of a stalking horse purchase agreement with Mercer for $60 million that served as the baseline bid at the auction. Immediately upon Miller Buckfire's engagement in early February 2023, Miller Buckfire launched a broad-based marketing effort contacting both strategic buyers and financial buyers and investors. In total, the pre-petition marketing process ran a full 70 days and resulted in the stalking horse bid from Mercer. 74 prospective buyers were solicited, of which 37 executed non-disclosure agreements, and 18 prospective investors were solicited, of which 7 executed non-disclosure agreements. The parties that executed non-disclosure agreements received access to the company's virtual data room and were offered management meetings and site visits. By March 8, 2023, 5 prospective buyers provided non-binding indications of interest. Of these 5 parties, 4 were selected to continue to the second round of the process and were provided with access to additional diligence in the data room, continued access to the company management, and site visits and a draft asset purchase agreement. Miller Buckfire requested binding bids from these 4 parties by March 24, 2023. On March 24, 2023, Miller Buckfire received 2 bids and provided them to the company. Following receipt of the 2 second-round bids, the company and its advisors worked with initial bidders to evaluate, solidify, and improve the initial bids received. Ultimately, after such evaluation and analysis, the bid by Mercer International was determined as the highest or otherwise best initial offer, and the company and its advisors engaged with the stalking horse bidder concerning the terms of a purchase agreement. On April 21, 2023, the debtors and the stalking horse bidder entered into the stalking horse purchase agreement. The stalking horse purchase agreement provided for, among other things, the purchase of the debtors' U.S. and Canadian assets, along with the assumption of certain assumed liabilities, as set forth in the stalking horse purchase agreement, for a purchase price of $60 million. The stalking horse purchase agreement, as Your Honor is aware, was also subject to certain bid protections in favor of the stalking horse bidder, consisting of a breakup fee of $1.8 million and an expense reimbursement not to exceed $600,000. Promptly following the petition date, Miller Buckfire began soliciting offers for a potential overbid of the stalking horse purchase agreement. On April 25, 2023, Miller Buckfire contacted all previously solicited prospective buyers that had executed a non-disclosure agreement. And on April 28, 2023, Miller Buckfire contacted all previously solicited prospective buyers that had not executed non-disclosure agreements. Miller Buckfire notified these parties of the stalking horse bid and solicited interest in participating in the process. During the post-petition period, Miller Buckfire contacted an additional 24 buyers, of which 8 executed non-disclosure agreements, for a total of 98 buyers contacted, of which 45 executed non-disclosure agreements. Your Honor, on May 8, 2023, the court entered the bidding procedures order. The bidding procedures order approved the bidding procedures for the sale of the debtor's assets. Pursuant to the bidding procedures, potential bidders that wanted to make a qualified bid for the debtor's assets were required to transmit a qualified bid to the notice parties so as to actually be received on or before May 23, 2023 at 4 p.m. Prior to the bid deadline, the debtors received what it determined in consultation with the consultation parties to be a qualified overbid from the Weyerhaeuser company in the amount of $70 million to acquire substantially all the assets of the debtors, but only related to the United States operations.
So, not to interrupt, just to make sure I understand how this unfolded, am I right that at every step along the way, the Mercer bid was for the assets of both the U.S. and Canadian entities, and the Weyerhaeuser at every step along the way was only for the U.S. entities?
That's correct, except there's one little twist at the end.
Okay.
But I'll get to that.
Okay.
But yes.
Okay.
And that's where we ended up, Your Honor.
Okay.
The debtors also received a non-qualifying bid from Allfab Building Components in the amount of $200,000 for some of the debtors' equipment located in Canada. Given the receipt of the Weyerhaeuser bid on May 24, 2023, the debtors conducted an auction pursuant to the bidding procedures. At the outset of the auction, the debtors determined, in consultation with the consultation parties, that the highest and best initial bid for the debtors' assets was offered by Weyerhaeuser. And that was the bid at $70 million, Your Honor. After several rounds of bidding between the stalking horse bidder and Weyerhaeuser, the debtors determined, in consultation with the consultation parties, that the highest or otherwise best offer for the debtors' assets was provided by Mercer in the amount of $83.5 million. That Mercer was the winning bidder, and its bid was the winning bid at the auction. Additionally, the debtors designated Weyerhaeuser with a final bid in the amount of $80 million US dollars as the backup bidder in its bid to acquire substantially all of the assets of the debtors related to the United States operations was the backup bid under the bidding procedures order. Your Honor, there was a subsequent bid made by Weyerhaeuser that I wasn't really going to talk about, but since Your Honor asked the question, they did try to allocate some money to buy some equipment in Canada. But the debtors, in consultation with the consultation parties, determined that it was not a higher and better bid. Fine. Your Honor, the debtors believe that they fully complied with the bidding procedures order and that the process resulted in the highest or otherwise best offer for the debtors' assets. And Your Honor, I think it's a remarkable result. We went from $60 million, actually initially $50 million to $60 million to $83.5 million. So I think we all believe that it was a successful auction for the estates. Your Honor, as evidence in support of the sale, the debtors would submit the declaration of Kevin Haggard in support of the debtors' bidding procedures motion and motion to shorten notice regarding the bidding procedures motion. That's at docket number 19. That was filed on 4/24/23. And the supplemental declaration of Kevin Haggard in support of the debtor's sale motion. That's at docket number 183, and that was filed on May 26, 2023. Mr. Haggard is here today and available for cross-examination.
Okay. First of all, is there any party in interest that would object to the admission into evidence of the two declarations that Mr. Chipman described, the ones that DI 19 and DI 183? Seeing none, they will be admitted. Is there any party in interest that would like the opportunity to cross-examine Mr. Haggard? Seeing no one, you can continue.
Thank you, Your Honor. Your Honor, also in support, the debtors would also offer into evidence the auction transcript. And I do have some copies here with me, Your Honor, if I may approach.
You may.
How many copies would the court need?
I think I only need one.
You only need one. Your Honor, may I mark this debtor's one?
You certainly may.
Thank you.
Thank you. So you've moved this into evidence, so I guess I now, instead of reading it, should ask if there is any party that objects to the admission into evidence of the auction transcript, which Mr. Chipman has marked as Debtors Exhibit 1. Okay, seeing no objection, it will be admitted.
Thank you, Your Honor. Your Honor, we, right before the hearing, I think a couple hours ago, we filed a revised sale order with the black lines showing changes as a result of the auction. And I believe it also contains some informal comments from various parties. And I think everybody here has agreed that that form of order is acceptable. I do know that before I conclude, I know that counsel for Mercer would like to address the court with regard to a declaration that was filed by the purchaser.
Okay.
So at this time, if it's okay, I'd cede the podium to counsel for the purchaser.
Certainly.
Thank you, Your Honor.
Thank you, Mr. Shipman.
Good afternoon, Judge. Drew Dilworth from Miami, Florida, on behalf of Mercer International. Just to supplement the evidence submitted by Debtors Counsel, we had filed a declaration at docket entry 194, declaration of Brian Merwin, M-E-R-W-I-N, Vice President of Corporate Development at Mercer, as to Mercer's good faith and ability to consummate the closing and provide adequate assurance of future performance, although as of today there are no contracts being assumed. Your Honor, Mr. Merwin is in the courtroom and available for cross-examination, but I would ask that that also be admitted into the record as evidence of this.
Okay. Is there any party in interest that objects to the introduction to evidence of Mr. Merwin's declaration, which is at DI 194? Okay. Seeing none, that will be admitted. Is there any party in interest that would like to cross-examine Mr. Merwin? Okay. Seeing none, you can proceed.
Your Honor, that's all I wanted to add.
Okay. Very well. Thank you very much. Mr. Chipman.
Thank you, Your Honor. And with that, unless Your Honor has any questions and subject to anything else anyone else would like to add, the debtors believe that the sale to Mercer is the best result that the debtors were able to obtain in the sale process and respectfully request that the court enter the revised order approving the sale motion.
Okay. So, Mr. Chipman, let me say a few things. First, let me just say that I share your view that it was a very successful auction and a terrific outcome for the estates under the circumstances, and all of you have my thanks and appreciation for the good and hard work. Unless I'm missing something, and perhaps because of how hard everyone's working, when I reviewed the sale order, there are a couple of nits that I just wanted to flag.
Sure.
I'm now working off of the clean version that was submitted at DI 198, and let me not understate the possibility that I am missing something, but in this final version, so on page 2, in the 1, 2, 3, 4th line, there's a bullet point where I think you probably intended to fill in a date.
Got it, Your Honor.
On page 3, about 2/3 of the way down, there's another bullet point.
Oh, yeah.
And then after that, Mr. Carmel's name is in brackets, sort of as if it was subject to being changed. Those brackets should probably come out.
We'll
right?
fix that, Your Honor. Sorry to miss that.
No worries. I just, before I signed the order, thought I'm mostly just showing off to show that I tried to read it.
Your Honor, and just so the record's clear, what we were going to do is go back, make sure everyone's okay with the order, and make sure there's no other additional changes, and then we'd upload a final version of the order.
Okay, that's
Because
fine.
I think we have to attach some things also.
You need to attach the APA, right, exactly.
Right.
So there's another bullet on page 5. There's stuff like that. So if you want just another chance to read it, to clean it up and submit it as final, if we're talking about these kinds of nits, not substantive edits, then that's entirely fine. And let me just ask this before I fully sign off. Is there any party in interest that wants to be heard with respect to the approval of the sale motion? Okay, so I'm good with it. It seems like everyone has had an opportunity to be heard and there are no objections, and subject to your giving it a clean read.
Yes.
And I was only going through it in case there was a time urgency that it could be done. But
I appreciate that.
if you want to just take another read and submit it when it's uploaded, we will go ahead and enter it. Let me ask this question. Is there, in terms of time urgency, is this something that needs to be signed today, such that if it takes more than an hour or two to upload, or is it?
Your Honor, just because there's a hearing in Canada tomorrow to approve this, I think it has to be
Entered today,
entered
okay,
today, and we will upload it as soon as the hearing's over.
fine.
All we were trying to do with this black and white was to show the agreed upon changes. This was
Got
not
it.
an order for you to enter.
Okay, got it. Okay, understood.
Right.
No concerns there. So I'll give you all the opportunity after this to go back, do cleanup edits, upload it, and when it's uploaded, we will go ahead and enter it, and we can get that done today, no problem.
Thank you, Your Honor. So unless Your Honor has any other questions on the sale motion, we will make those changes and get the order uploaded as soon as possible.
Terrific, very well. I guess that brings us to the Kerp and Keep.
Yes. As Your Honor is aware, on the Kerp and Keep, we did receive 2 objections to this motion. One by the United States trustee, another by Walmart. These objections were related only to the Keep portion of the motion. There were no objections to the Kerp. I am pleased to report that over the long weekend, the parties were able to resolve those objections, and we're here today on a fully consensual basis. The objections were resolved, Your Honor, by placing an overall cap on the KEEP program at $950,000, which is a voluntary reduction of approximately $500,000. As set forth in the motion, the KEEP is open to Matthew Carmel, the debtor's interim chief executive officer, and Sean Turkington, the debtor's interim chief financial officer. And it's important to note, Your Honor, a portion of the voluntary reduction that is being credited to the $175,000 bonus received by Mr. Carmel prior to the petition date. And therefore, you will see in the language that the debtors have waived any further avoidance action or return of those funds, because that was all part of the negotiation. As the court is aware from the pleadings, the KEEP participants were hired prior to the petition date to assist the debtors in their restructuring efforts and have been and will continue to be integral to the debtors' efforts to maximize value through the closing of the sale and beyond. As you just heard, the auction was very successful, creating more than $20 million of additional value for the creditors of these estates. A lot of that additional value was the result of the extraordinary efforts of the KEEP participants. Just one example, Your Honor. During the sale process and post-petition even, the KEEP participants were instrumental in bringing in new work to the Conway facility that resulted in the rehiring of 25 additional employees, allowing what we believe the Conway facility to be sold as a partial going concern rather than just as an idle plant. With regard to the KERP, Your Honor, the KERP is open to 13 of the debtor's non-executive employees. These personnel are critical to the debtor's organizational structure and necessary to carry out the day-to-day operations of the debtor's business. None of the KERP participants are officers of the debtors or otherwise persons that are in control of the debtors. The KERP participants instead include, among others, managers, manufacturing supervisors, project managers, technology service providers, plant managers, human resources, and quality control personnel. Your Honor, the maximum total cost of the KERP is approximately $420,000 US, with individual amounts equivalent to 3 months of annual salary for each of the key employees. Each retention bonus ranges from $19,000 to $48,000. Your Honor, there's been no objections to the KERP. And in support of this motion, the debtors would offer into evidence the declaration of Brian Cumberland in support of this motion, and that's at docket number 140, filed on May 19, 2023. To save money, I think all the parties agreed that we wouldn't fly in these 2 witnesses unless the hearing was contested. I believe Mr. Cumberland is on the Zoom hearing and is available if Your Honor has any questions or anyone wants to cross-examine him.
Okay, is there any objection to the admission to evidence of Mr. Cumberland's declaration, which is at DI 140? Seeing none, it will be admitted. Does any party wish to cross-examine Mr. Cumberland? Seeing no one, you may proceed. And just so everyone's clear, on uncontested motions, I am fine with proceeding this way. Just so everyone understands, my chamber's procedures are if something's contested and we expect to have a dispute, people need to be here. Where something is within everyone's good faith, uncontested, you can proceed exactly as you have, and if someone shows up at the last minute who didn't raise an objection, we can deal with it. Just so everyone understands, I'm entirely fine with your proceeding as you have.
Appreciate that, Your Honor. Your Honor, we would also, in support of the motion, submit the declaration of Anthony Tillman. In support of the debtor's motion, Mr. Tillman is with Alvarez and Marcel, and I believe he is also attending via Zoom today to save the estate some money.
Okay, and I had this somewhere, but his declaration is, just the record is clear, is on the docket at DI.
Oh, I'm sorry, that's docket number 141, Your Honor, and it was filed on May 19, 2023.
Okay. So is there any objection to the admission into evidence of Mr. Tillman's declaration at DI 141? Seeing none, it will be admitted. Any party in interest would like to cross-examine Mr. Tillman? Okay, seeing none, you can proceed.
Your Honor, we also filed a revised form of order with a black line showing changes as a result of the resolution of the U.S. trustee and Walmart objections. I'm not sure if Your Honor's had a chance to review that.
I have.
Okay. Unless Your Honor has any other questions or wants any more details, and subject to anything else that anyone else would like to add, the debtors respectfully request that the court enter the proposed revised order approving this motion.
Okay. Is there any party in interest that would like to be heard with respect to the curb and keep motion? Mr. Hackman.
Good afternoon, Your Honor. It may please the court, Ben Hackman for the U.S. trustee. I rise to confirm that our limited objection at docket item 192 is resolved. And I thank counsel, in particular Mr. Chipman, for working with us over the weekend to respond to our concerns. Thank you, Your Honor.
Well, thank you, Mr. Hackman. Anyone else would like the opportunity to be heard with respect to the curb and keep motion? Mr. Newman.
Thank you, Your Honor. Ari Newman, Greenberg Charge for Walmart, and I echo Mr. Hackman's sentiments. Just wanted to thank Mr. Chipman for working with us over the holiday weekend to resolve our concerns and to confirm that from Walmart's perspective, those concerns have now been resolved.
Very well. Thank you, Mr. Newman. Any other party in interest that would like the opportunity to be heard with respect to the curb and keep motion? Okay. Mr. Chipman, I've reviewed the motion, the now moot objections. I guess everyone's got to be good at something. Uncontested motions are really my specialty. Having reviewed it, even when it's uncontested, I review it subject to a sort of, does anything here threaten the integrity of the process or otherwise shock my conscience? I'll say, in light of the resolution you've reached, nothing does, and we are happy to enter that order.
Thank you, Your Honor. And
I take it that also has to be uploaded, is that right?
I believe that order, I'll make sure it's uploaded right away, but I don't think there's going to be any changes to that order.
Okay, so if it already is uploaded, we can go ahead and
Yes.
enter it. And if
Yes.
it isn't, we'll wait till it is.
Right. And again, with the road to the sale order, we need to go back and do some attachments and clean it up and get it uploaded before Your Honor orders it.
Terrific.
Thank you.
Okay. Does that take us to the end of your agenda?
I think that's everything the debtors had, Your Honor. And I want
Okay.
to thank Your Honor and Your Honor staff for their time today. Appreciate it.
It's our job. We're happy to do it. While we're here, is there any other way in which the court can be helpful to any of the parties in interest? Okay, if not, I want to, again, thank everyone for the terrific work in connection with a very favorable outcome for the estate, as well as saving me from having to do anything hard. With that, and in the absence of anyone else who wants to raise anything further, and seeing no one who does, and with my appreciation, we are adjourned. Thank you.
Thank you, Your Honor.